we're paying attention to that and able to mute people if they haven't noticed. Good evening again, Assemblymember Chantel Jackson here. I'm driving home from Albany, so my apologies for not being on screen, and forgive me if the service goes out. This is being recorded, so it will go live on my YouTube. I'm sorry, I'm saying live, but it will go on my YouTube channel, so you can go back and look at it. I want to say thank you to everyone who put this together, especially Team Jackson for being visionaries. Estate plan is extremely important to me. My dad, I shared this story a few times already, but my dad passed away in 2022, and he didn't have anything really in place. And so when we had to make decisions, it's 5 girls. He had 5 daughters. And when we had to make decisions, we didn't know what to do with anything. They called me asking me for his eyes. I wasn't sure if he was a donor. We had to figure out what to do with his bills and closing out accounts and all kinds of things. And so I want us to stop playing catch up and start planning ahead and take care of ourselves and our families and making sure that we have everything in place. It took my dad passing for me to realize I need to put things in place for my children. And so I'm glad that we're on this call. Even people who do not have children, it's important for you to tell your family and friends what you want to see happen if you become ill, where you can't take care of your finances, or God forbid you pass away. So thank you again for having this conversation. If you want to share in the chat while you joined this call, feel free to do so. We can make this as interactive as possible. So I'm going to be quiet and let the professionals take over.
Mitchell, whenever you want to begin. Thank you again.
Thank you. I am going to go ahead and share my screen. So I appreciate that that introduction. Estate planning is an important topic, and I will talk about in a moment all the reasons why all of us need an estate plan. And this really is not a fun topic to think about or talk about, but I want to help you today know that know a couple things, and chief among them is that you need a plan, and then that it's not nearly as difficult to make a plan as you might be thinking. So there's me. I'm Mitch. I am associate counsel here at Trust and Will, and we're an online estate planning platform. But before that, I was a lawyer in private practice, so I was helping individual clients like you, and I was helping them plan for their estates, and I was also helping those who lost a loved one, navigate the probate process. And this is a little bit about Trust and Will, but I'm going to spend most of the time talking about core estate planning concepts because that's why I'm here. I'm here to give you information, educate yourself. But we are an online estate planning platform. We make this easy for folks to do. We're a more affordable option than going to a lawyer. But if you do want to speak with a lawyer, that's an add-on where you can schedule some time to talk with an attorney. So let's dive right into what we're going to talk about. First is we'll learn what estate planning is and why it's important. Then we'll talk a little bit about what documents are involved in estate plan. And then we'll compare 2 of the, really pillars of estate planning, a will and a trust. What are their differences? We're going to talk about healthcare documents too. This one is a very important one that I want you to walk away with today. If you do nothing else, start thinking about planning for these documents. Who needs an estate plan? I already answered this question. I just can't help myself when I talk about it. Everybody needs an estate plan. And then I do want this to be interactive. Now, I am a lawyer, and I'm not your lawyer. I'm not going to give you individual legal advice, but I can answer general questions. I know some of you probably have very specific questions, and I apologize. I won't be able to answer them specifically, but I will try to answer them as best I can so that this group can get the most from this session. So first, what's estate planning? Well, very simply, and I like to put this in non-legal terms, estate planning is preparing today for what happens tomorrow. It's making a plan. Because most people end up leaving their assets and their legacies subject to lengthy, expensive, and complicated legal processes. That's the default when you don't make a plan, is that your state, New York State, makes a plan for you. And that might not be the right fit for you. I know I'm not trying to scare you, but making a plan is something that you do for your family first and foremost. We think maybe of it being something sort of selfish, but it's actually a gift to arm your family with information about what you want, both in sickness and when you're no longer here. So why do we make an estate plan? First is to protect our loved ones, make sure they have a clear template for what to do and who's going to be in charge. Another is the one that everybody thinks of. Everybody has something. Everybody has some property of some kind. We leave it behind when we leave this world. And so your estate plan is a plan for transferring assets, transferring your property. And then another thing that you can do in your estate plan is naming guardians for minors or pets. And then I touched on this earlier. You have an opportunity here to talk about what you want your health care decisions to be when you're incapacitated. And then finally, this is an opportunity too to benefit organizations that you care about, organizations, causes that you care about. Leave something, leave a legacy of some kind, a legacy gift, maybe some property. So what are the estate planning documents? Hold on one moment. I am in a meeting. I'm so sorry. I don't know where she is. Go find her. So estate planning documents. The typical documents are right there at the bottom of the screen. There's a will, a trust, and then healthcare documents, which I'll describe in more detail in a moment. So these documents they're legal documents at their core, but they really just they involve the types of decisions that you want. So they're just an opportunity for you. I said earlier, there's a default plan that New York State makes for you. This is an opportunity to either confirm that plan. So, if I am married, I confirm that I want my spouse to be primary decision maker, or maybe it's, a second marriage, or maybe I'm a widow or a widower, and it's not clear which of my adult children I want to step in and make those decisions for me. So these are documents that reflect decisions that we've made in advance. And again, that's that planning today for what happens tomorrow. So what's a will? I think a lot of us are mostly familiar with this document. There are some things you probably don't know that a will does. I think the thing that a lot of us are familiar with is a will says what happens to our property, right? It says who gets it. But beyond that, that's only one of the three purposes listed on this slide. That's just the distribution of assets. That is the fun part, right? You leave some property behind, and for your beneficiaries, the people that you leave behind, they get something from you. But also you have the opportunity here to name guardians for minor children or disabled children, also caretakers for pets. And then you can make decisions about your final arrangements. Do you want to be buried? Do you want to be cremated? What do you want your memorial service to look like? And another thing that you get to do in this document is to say who is in charge. That person's called an executor or a personal representative. And you get to say, I would like for this person to serve. Now, probate, which is the process that every will has to go through, it is a court process. And so the court has to confirm your pick. It's just a nomination, and that person doesn't have authority until you die. And the court has actually entered an order appointing that person. So, sorry to talk about administration of a will. All wills go through probate, and it is a court process to validate and enforce the terms of your will. So first and foremost, we're checking to make sure that document actually is your will. And once the courts confirm that, they're looking to see, okay, the person you named as executor, are they ready, willing, and able to serve? And if all of those things are true, then the court will go ahead and appoint your executor or personal representative. And then from that moment, your executor has court authority to step in and manage your estate. So once they have that authority, the managing of the administration, they're collecting assets. So any property that you have, they now are taking possession of it, including bank accounts and things like that. They're going to pay any last expenses out of that and pay creditors. And then finally, the last step is once they've done the other steps of collecting and settling any expenses or debts, they're going to distribute what's left over to the beneficiaries named in your plan. Because probate is a court process, it can be undesirable to go through that process. It can be slow, it can be stressful, also can be expensive because a lot of times your family will hire an attorney, and the attorney and the court costs together can be expensive. One thing that I want to mention too is that in New York, in certain counties, there's a several months long backlog in the surrogate court. So your family is waiting several months for your case to even be heard. Not to mention they're having to wait for the person to be appointed. So compare a will to a trust, or first let's describe what a trust is and then we'll compare them. A trust is like a will in that we're establishing a plan for what we want to happen to our property, and we're naming somebody to be in charge of it. And it's conceptually a little more complex. So I want to define some terms here. It's a legal agreement. It's a legal document, just like a will. But this time it's an agreement between a settlor and a trustee. And a settlor is somebody who creates the trust. So if I create a trust, I'm the settlor of my own trust. The trustee is typically a third party that I've named. They're kind of like my personal representative or executor, but their authority can begin while I'm still alive, and it's not subject to a court process. And then finally, the reason for the trust, why we set up a trust, is because all trusts have beneficiaries. The settlor creates the trust for the benefit of the beneficiaries, and the trustee is the one who manages it for the benefit of the beneficiaries. So benefits of a trust compared to a will: it avoids probate for assets that are placed into trust. It can also be a mechanism for giving us greater control over assets. So they're often used for minor children. I want to leave property to my children, but they're not old enough to manage it. So I'm going to name a trustee to manage it for their benefit until they reach a certain age. Trusts are also powerful tools for doing tax planning. You can still do tax planning and wills, but usually trusts are the tool of choice for more sophisticated tax planning. And then finally, incapacity planning. If I can set up a trust and name a trustee to step in and manage my assets that I've put in the trust when I'm sick, when I'm unable to manage my own financial affairs, and that's not a court process. So they're a powerful tool for incapacity planning. And then finally, I want to talk about, I defined who a trustee is, but I want to talk about that role of trustee and how important it is, and also compare it a little bit to the role of personal representative. Fundamentally, it's in the name. It is a role of trust. I want to name somebody who I trust without question to be able to manage assets, who I think will do a good job, who I think maybe has the time. It is a job, and it is a serious responsibility. And, somebody who I have talked with in advance about taking on this role. So in one slide, what's the difference between a will and trust? Because I've been kind of talking about them by comparison already. Wills, again, they're simpler documents. We can do a couple of things in them, like name guardians for kids and pets, and specify where we want our assets to go and talk about our final arrangements. But one of the downsides is that all wills go through probate after death, and we can't have more complex distribution schemes. They just generally have to be outright to that person. Trusts give us greater control over the when and how of asset distribution. So I don't have to say, I want to just give this asset to that person outright. My example earlier with minor children, I can say, hold on to that. Maybe pay out the income, make sure they're taken care of, but don't pay out the large sum of money to them right now. Trusts only apply to assets that we've actually put into the trust. So I'll talk about that probably a little bit more in a moment. I'm sure I might even have questions about it. But the benefit of a trust is that we can minimize or avoid probate entirely. One of the main reasons people use trusts. And but that only applies for that bullet point above it, again, for assets that are properly funded into the trust. And a trust is something that we set up while we're still alive. A will is something we do while we're still alive, but it doesn't go in effect until we have died. Whereas a trust I set up while I'm alive, and I'm going to do some of that administrative work of, say, transferring my house into the trust while I'm still alive. So when might you consider a trust? My example, again, of younger children, if I want to spread out distributions, I want to stagger them, or I want to incentivize certain conduct, like graduating from a trade school or graduating from college, even just reaching a certain age. You might also want to use them in blended families, where there's second or third marriage, and you want to make sure your spouse is taken care of, but your children are maybe going to be the primary beneficiaries of your wealth, because you want to ensure that your children are the primary beneficiaries of your legacy. Another reason people like to use trusts is because of privacy concerns. Wills become public once they're filed in the probate or surrogates court, while trusts are private documents and they're not filed with any court, so they remain private. And then finally, a reason you consider a trust is just probate avoidance. I think that's one of the core reasons. And taxes, we won't go into great detail about that, but trusts are powerful tools for helping you plan around tax minimization and doing specific, helping to achieve pretty specific needs around taxes. And then finally, again, I think this is one of the most important things to consider. We talk about healthcare documents. So you may not be able to see it too well on your screen, depending upon the size of the screen you're viewing it on. But for healthcare documents, we have a HIPAA authorization, an advanced healthcare directive, and a power of attorney. So the power of attorney is, there are two really types of powers of attorney, and there's a little bit of confusion here because different states refer to them differently. But there's a power of attorney for financial decisions. And really that is, I'm naming somebody to step in and make all decisions related to my finances, to my bills, to accessing my accounts. That is a power of attorney where I'm naming that agent to step in and do those things for me, as though they were me. So that covers everything except for medical decision-making. That's all in one document. And there's also a medical power of attorney, or sometimes called a healthcare proxy, where it only covers medical decision-making. I, again, am naming an agent, somebody to step in and make decisions for me when I can't, to, communicate what it is that I would have wanted, if I still could communicate. And then to that last point of the healthcare agent or healthcare proxy, I also, in a healthcare directive, sometimes called a living will, can specify in advance my preferences, usually about end of life care. Do I want them to give me artificial nutrition or hydration, or do I not want them to do that? Do I want my life to be sustained or not? Questions like that. Those are very hard decisions to make, but you have an opportunity here to think about it in advance and sort of unburden your family from having to make those decisions for you. And then finally, a HIPAA authorization. That's a document that anybody named on that document, you're giving authorization for your healthcare providers, doctors, facilities to communicate with your loved ones about your care, and then to also, view healthcare records as well. And then finally, who needs an estate plan? Well, I already answered this question at the top, but everyone needs an estate plan. Every adult, every person over the age of 18. And on the right-hand side here, you see all the reasons why people typically start thinking about it. Some of them good, some of them not so good. But these are all reasons for us to think about estate planning, getting married, adding children to our family. Maybe we are in the accumulation stage of our life. We finally are starting to get some property where we're starting to think, oh, I have something that I want to protect, that I want to make sure it goes to the right people. Same thing with purchasing real estate. And then medical concerns. I saw this often. It was, direct medical concerns. Maybe I got a bad diagnosis, so I know for sure I need a plan, or I just walked a family member through that process. And I knew the importance of getting a plan in place, having gone through it firsthand. And then this is another thing to consider is if you have a plan, or once you have a plan, make it count and make it current. You've got to get this across the finish line. So getting it signed, just having these documents is not enough. You have to have them signed properly, have them in some cases witnessed properly. And then once you do get it in place and get it fully signed, revisit it. Think about it anytime, going back to the last slide, the previous slide, anytime one of these events happens, revisit the plan. And also maybe if the life of a person you've named in your plan to step in for you has changed, revisit when they've had a major life event, because that may change who you want to step in or who feels comfortable stepping in, helping you. And then this one is super important. If you walk away with nothing else, talk about this with your family. I know it's difficult. It's never not difficult. I'm a professional in this. I've done it a lot with people firsthand, but it's different when it's your own family. And this is not a one and done conversation. This is an ongoing conversation where talk about what's important to you. Maybe bring it up at the dinner table and say, I want to talk about this. We don't have to talk about it right now, but I want you to know that it's important we talk about this. Preview it so that you have some space to seriously consider it and let people know, hey, I want to name you in my plan, or I've made this decision and here's why. And that's the end of my presentation. I know we have questions in the chat, it looks like, and I expect we'll also have some Q&A, but I do, before I open it up, want to mention that anybody viewing this, you can get a free will by going to trustandwill.com/NYC workshop and entering that promo code on the screen, NYC workshop 2024. And hopefully you find we're very proud of how much education there is on our website and how easy we've made it for you. We also have support people that you can chat with and call. But if nothing else, if you don't have an estate plan, please take advantage of this offer. It's very important. I'll open it to questions.
Can you talk to like irrevocable trust? And I forgot what the other title is.
Yes.
Revocable trust and irrevocable trust? Yeah.
Yes. Yeah. So I did not mention that on purpose, but I'm also happy to describe the difference. So the most common trust, and really the trust that I'm thinking of when I'm describing it in this presentation, is a revocable trust. And you'll often hear them referred to as a revocable living trust or just a living trust. Those all refer to the same thing. And the revocable part of this just means that I set it up, and anytime while I'm alive, I can change it, I can get rid of it, I can take assets out of it, I can put assets into it. So in that way, it's kind of similar to a will, because a will is a revocable document while I'm still alive. I can change it up until the very end. Same thing with a revocable living trust. The irrevocable trust is really lots of different potential types of trust, but its distinction is once I set it up, I really cannot change it without a huge amount of effort. It's always going to be a court process of some kind, and they're designed to be irrevocable. And usually they have a reason for that. One, the chief among them is doing some tax planning. Another is potentially maybe some Medicaid planning way in advance. But describing how those work is sort of outside the scope of estate planning 101. Just know that one is the common tool, that's the revocable living trust, and that's the one that we provide on our site too. The irrevocable trust is less common, a very powerful tool, but once you set it up, it's impossible to change it.
Thank you. And who's gonna help man the chat?
I see one of the questions is, can you get these slides emailed to you? And I'd be happy to do that. I'll send that to your office.
Tiara Robinson asks if you can have multiple powers of attorneys.
Yes. So I want to be precise about this. It's good practice to have multiples. So, but only in one particular way. You don't really want to name co-agents. So that's multiple agents under a power of attorney serving at the same time. Generally, that just introduces logistical challenges. I found that clients who did that, they didn't want to disappoint any of their children. Usually they're naming all children as co-agents. And it just makes it more difficult. Like all three of them have to appear at the same bank branch and they probably don't live in the same town. So choose one. But beyond that, you can name alternates. So if one of them's unable to serve, you can and you should name backups. And so that's where you have multiple agents named in one document. It's just, you should name one at a time in descending order, where I name this person first. They're really my first pick. But if that person's not able to serve, this person's great. They'll step right in. And then I'll just keep going.
Oh,
go ahead.
I'm sorry. My name is Camilla Minifield. I wanted to ask 2 questions. How can we get in touch with your organization so we can have maybe a consultation individually if we're interested? And
Right.
And my
Second
second
question
was when's the next time you're doing something like this? Because I have so many friends that's interested and they told me they couldn't get in, but I told them that they probably didn't register. So when is the next time this presentation is gonna occur?
So that I don't know. I do know this is being recorded and will be available on YouTube. And I love these. I'm happy to do more of them. I don't know rescheduling them, but I do know that this is recorded and will be available on YouTube later. As to the first question about I'm sorry, I forgot the first question.
The first question is, how do I begin to make a will or living trust before I go to, if I wanted to meet with someone on your team, how do I get in touch with people?
So if you go to our website, trustandwill.com, and it's on the slide that I showed earlier and also in the presentation we'll share. But if you go to trustandwill.com and you start and create an account, there is chat on the website and there's also phone support available. We're not a law firm, so we don't give individual legal advice. We have a network of attorneys where if you want to visit with an attorney about your specific legal situation, you can do that. But that's an added cost. But our staff or support staff, who are great, can kind of help point you to general education materials. There's a lot on our website. There's also a lot they can help you, like common questions that people have. They're great for that, but answering your legal questions, they can't do that. But just want to underscore, to get started, go to trustandwill.com. It's a very simple guided interview. And as you go through, there's information about the question you're being asked and like sort of a frequently asked questions. So hopefully that answers a lot of your questions. But if you find one that isn't answered, that's what our frontline support staff is for.
Okay, thank you very much.
I see Sharon G has her hand raised.
Yes, hi, good evening, everyone. So my question is, I see that you offer, because we're taking a presentation, we can get a free will set up. What is the additional cost to have a trust also?
Right. I think the offer is the cost of the will. So that's a $299 value would be applied to the trust. And I'm sorry, I'm blanking on pricing at the time, but the free will can be applied to a trust package. You'll just pay the difference.
Because it's more advisable to have a will in a trust, correct?
It really depends upon your individual situation. I can't tell you what's best for you. A lot of people do choose a trust, and for the circumstances I mentioned earlier in the presentation about like maybe I want to have staggered distributions, maybe I have minor children. Another reason, not on the slides, but another reason people choose is they have property in multiple states. That especially real property. And avoiding probate in more than one state is generally a good thing.
Okay. So when we go online to set up the will, it's just an online thing. We don't speak to anyone in person.
Right. Yeah, you can do it on your own schedule. There is during like normal business hours, there is chat support available on the site with real humans. But there's not, you go on, you create an account and start it on your own.
Okay. How long is the promo code good for?
I believe it is good through June 30th.
Okay. Thank you.
Thank you. Crystal, you want to go back to the chat?
So Ms. Dana Eldon asks, would you advise to put some money into a pool trust? Will that be helpful for her children to have immediate access to it? And then she follows up with a second question, but I'm gonna let you answer the first one.
Okay. So to answer this generally, one benefit of a trust is, yes, being able to have immediate access to the funds. There are other ways to do it, but comparing it to a will where I have an account in my name when I die, and I have my executor or personal representative has to wait for the court to appoint them to get access to those funds. They don't have authority to access them. The bank would say, I'm sorry, you don't have a piece of paper telling me you have authority, so you can't access it. Whereas with a trust, if I set that up and my bank account is instead in my trust, then my trustee, if something happens to me, has immediate access to those funds. They just have to show, they are the current serving trustee, which is not a court process for them to show that authority.
Her second question was, is having a written statement considered a living will, and is that accepted as valid in a case that she passes away, God forbid, or should she go to probate court to have it filled?
Right. So I want to be clear here, because I'm not sure. I want to clear up just in case there be a misconception here. A living will is that healthcare directive that I mentioned earlier. It's not the last will and testament. It's not the will document that goes through probate. The living will is, I'm saying what my preferences are for my end of life care. So just to be clear on that. But a last will and testament, or just a will, that's the document where New York does recognize what's called a holographic or handwritten will, but it's best practice to have a typed document that you sign at the end, and your witnesses is required to be witnessed by two witnesses. Your witnesses also sign. So it's kind of, that was a long way of answering the question, but probably, well, here's the guidance. Here's the general guidance. You should have a will that is witnessed by two witnesses and signed by you at the end. And typically that's going to be typed up. And it's not generally recommended to have something that you just wrote out. Even if states like in New York, they might recognize those. There's always a hedge there. The best practice is what lawyers do, which is lawyers, have forms that they type up and prepare for clients, and they get them witnessed and notarized.
But I'm sorry to interrupt, but my first question was dealing with pool trusts. So I have a pool trust account already set up for my family. Will that be acknowledged and respected, or do I have to leave instructions for that pool trust and how it's going to be handled after my death?
Yeah, I'm not sure what you mean by pool trust. It could mean a couple of things.
So it's an account, a bank account of sorts that my two children have access to, where an amount of money is there for their need, if they should need it for whatever reason in regard to myself. There's a lump sum of money that's sitting there in the pool trust, and at times can be used for emergency bills or whatever. That's what I'm
Okay.
talking about.
Okay. Yeah, I mean, a general answer to that, if you have a trust set up and you have an account funded into that trust, whatever the trust says is going to happen with that would be respected if something were to happen to you. That's how they're designed to work.
Okay, just wanted to make sure. Thank you.
And remember, he's not our lawyer, so he's speaking generally. He can't speak to like our specific cases. So.
Correct. I want to be as helpful as I can, but I can't answer your specific questions about what's best for you.
All right, we have Ms. Joetta Brown. She wrote, who writes the irrevocable or revocable trust?
So oftentimes lawyers do, but it doesn't have to be a lawyer. So we do offer a trust on our website, the revocable trust. It's a legal document, but lawyers don't have a monopoly on legal documents as much as a lot of us like to think that we do. I don't even know if I said this. I always say it. Estate planning is for everyone. It's for you. It's for you whether you use a lawyer or not. You get to be in charge of your financial future here. So typically lawyers have written these, but the reason I joined a company like Trust and Will is that lawyers are not serving the needs of enough people. And these documents should be available to more of us. So even though lawyers historically, traditionally have been the ones writing those forms, that doesn't mean that you can't use a service like Trust and Will to make your own.
Next question. And
Next
people
one
can
is,
unmute if they
T.
want as
Arrow.
well.
I'm so sorry.
I was saying people can unmute as well and ask their question if they are able to.
I want to ask a question. This is Sheree Diggs. I want to find out the YouTube channel you're talking about, Chantel. Is it for you? Did I have to, if I want to access this webinar again, do I go to your channel on YouTube?
Yes, and I think my staff also just put it in the chat.
Okay, thank you. Thank you.
Yeah, and it's not live if I'm not mistaken, so it'll go up soon. As soon as we get the recording.
Hello.
Thank you.
Oh, it's live. I'm sorry.
Oh, hi.
It's live, and then it'll be there for viewing after.
Oh, can I ask a question now?
Yes.
Sure.
So I put it in the chat, but it hasn't been read yet. So question, can a nursing home take your trust? For payment, that is.
It's a good question. And there's not a simple answer for that. The generally private care nursing homes are not going to take your trust. That's one answer. But the answer to that is somewhat more complicated by a lot of folks don't have the money for private pay nursing home care. And so they rely upon state administered Medicaid programs for long-term care. And it's not so much taking trust payments as the trust assets might be considered a resource that would prevent you from being able to qualify for long-term care. But that's really a much broader discussion without an easy answer.
Thank you.
Mitch, who can see that you have a trust? Like, is there a database that shows all the trusts in New York, and then that's how people can like see what assets you have?
There is not, to my knowledge, anywhere a public repository of trusts. Now, one way that people can find out is that, and I'll answer a question in the chat in the process of this. Can your house be left in a trust? One way people can find out that a trust exists is by looking at real property records. So real property records are not secret anywhere. Just like probate records are not secret anywhere. Anybody can go down to the county office, the county register of deeds, and see who owns what. And so that's often where people can pick up on whether a trust exists. And I talked about earlier how trusts are private documents. So that's true. Nobody can see what your trust agreement says about who's in charge of distributions, but they could maybe piece together some of those things by seeing like, oh, Mitch transferred his house to his trust. And I could name my trust something completely unrelated to my name, but that deed transaction of transferring house that I previously owned into that trust would still show up. So there'd be a connection to me in the trust.
Question.
Sure.
Go ahead.
When setting up the trust, I have two questions actually. When setting up the trust, who else need to be paid besides the lawyer is my first question. And during setting up the trust, is that the time that you add someone's name to your property?
Okay. So setting up a trust, there's no cost to set it up other than you either have to pay a lawyer to draft it or pay a service like Trust and Will to help you create your own trust. There's nobody else that you have to pay at that time. Most trusts will provide for compensation for your trustee at some point. And so they can, under the terms of the trust, whatever it says about, can they pay themselves a reasonable amount? Can they pay themselves a percentage of assets? So trustee beyond direct family typically is a paid role. And then the cost of transferring assets to it. So, anytime you file a deed, there's a cost associated with it, right? And so when you do the deed into, my example earlier, from Mitch to his trust, I pay my county recorder, the filing fee to do that. Those are the costs of setting it up.
Okay. And you add the property during that time?
Yes, once you have signed the trust, that's when you start putting assets into it, doing the deed to transfer it.
Okay. Thank you.
We have Miss Stacy Robbins. She said, what should be considered when deciding between using a lawyer and a service like Trust and Will?
I love this question. It's a really good one, and it's one that I want everybody to consider here. So Trust and Will, we're not a law firm. And so that means that we can't and don't give legal advice. Lawyers give legal advice. It's like the core thing that lawyers do, right? You pay them so that they can tell you what they think's best for you. And I mentioned earlier that Trust and Will, we have an attorney network. So we have a network of independent attorneys where for an add-on fee of $300, you can ask a lawyer, hey, is this plan right for me? Am I making the right decisions? The advantage of using a service like Trust and Will is we really make it easy. It's much easier than your standard going to an attorney, making an appointment with them, filling out their clunky questionnaire. All of it's online. You can even do it on your phone if you wanted to. And we make that part easy. But our value prop isn't necessarily in being everything for everybody. You might have a very specific need that we don't serve. And so that's where lawyers come in to say, you know what, yeah, this doesn't work for you, or I can draft this thing that Trust and Will doesn't offer. But I encourage you, especially since you have the benefit of the promo code, go in, dig around, see if it works for you. It may well, we've designed it to work for the most possible people we can, but we're not for everybody. And there will always be a place for lawyers to, one, give advice. That's what lawyers will always be able to do. And then two, maybe to draft something that's particular to your needs.
Do people have multiple trusts?
Sometimes, yes. If you have a revocable living trust, typically that's going to be like the core operating system of your plan. You may not have multiples, but sometimes you might set up an irrevocable trust for a specific piece of property that you have a very specific goal in mind for, and that can work in concert with your revocable living trust.
Thank you.
I have a question. If you create a if you create a will and trust through your organization, but let's say down the road you come into some more money, and you want to add that into your trust, but you want to get some legal advice on it, can you take what you already have to a lawyer to get it amended?
You can. So once you set up a trust, whether it's with a lawyer or with a service like Trust and Will, the revocable living trust, you can amend it. You can add to it. You can take property out of it. You put property into it. You can change your trustees. You can change who the property goes to. All of those things are on the table. Oftentimes what you'll see lawyers do, if there's an old trust, they'll do what's called a restatement. It's just like a super amendment. It says, hey, ignore it. Like, we don't want to have to retitle everything. So Mitch already transferred his property to his trust. We don't have to have him undo that by transferring it out, transferring a new trust. But we do want to just level that trust and build a new one. So they'll do what's called a restatement. And that will, just fundamentally change what the trust says, but the trust still exists going back to the date when I first set it up. And that's the case where, like, again, whether you start with a lawyer or start with Trust and Will, it's interchangeable because it's your document to do what you want.
Okay, so also you have mentioned that trusts are private documents, unlike a will, which is public, correct? So
Correct, yeah.
How does that work when you have a will and trust?
So good question, and one that a topic I didn't quite touch on earlier is, as part of a trust plan, you're still going to have a will, because the will has a very specific purpose, which is, if I have a trust, probably that's meant to be the main plan for all of my assets. And so if I die with property that I didn't get into the trust, it's probably an accident. I probably just forgot about it or didn't get around to putting it into the trust. And so your will is what's called a pour over will. So it still goes through the probate process. It has one function, which is to pour that asset into my trust. My trust doesn't become a public document. It just, we see the will, which is a public document once it's filed in the surrogate's court. And we see that it transfers property into the trust, but that's all that people can see. They can't see, what the actual plan is in the trust itself.
Oh, so for a will, they could see everything.
Right.
So with a will and trust, they could see the will part, but they can't see the trust part.
Exactly.
Oh, okay.
So Mitch, where do these things exist? So there are many people who live alone. They may have a trust. How do the family, the friend, or even the state find out that this person has a trust when they pass away?
Yeah, so that's a real practical challenge, especially for people who live alone. And you kind of have to do a little bit of detective work, unfortunately. And a lot of times and this may become even more of a practical challenge, just more and more because people do online banking. It's harder to play detective with mail that somebody left in their apartment. But that's where I come back to, it's more important to have had those conversations and maybe even have a master list. You don't have to have account numbers, but a master list of institutions somebody banked with, whether they had a trust, where a copy of that trust is, where the original stored, stuff like that. That's all important stuff to know, and information to arm your trustee and your other loved ones with.
Great. Crystal, any more
Yes, we
questions from the
have
chat?
two
Okay.
more questions. We have another question from Tiara Robinson. At what age should one typically start estate planning?
At 18. So I know that's not when a lot of people start thinking about it, but if you have adult children, and they're starting out on their own, whether that's going off to college in the fall or they're starting to live on their own somewhere away from you, they probably still want you, if you're talking with them and you're thinking about their mortality, they probably still want you to have a say in what happens. But that's not really the default for parents of adults. And so that's why I say anyone starting at 18, because they might not have a lot of property or really any property, but they might be in an accident, and might want to make sure that mom or dad or grandma can step in. Like they have that piece of paper that says Mitch chose them to step in and be his advocate in advance. There's no question. There's no delay whatsoever. So that's where the healthcare documents, especially earlier in life, I think are more important to think about and consider, because we're all at some point are going to have an illness or hospitalization, and hopefully our long lives. Of course, we all know that mortality is inevitable, but we sometimes forget that serious sickness is somewhat inevitable for most of us too.
Does your life insurance policy go in your trust, or is that two separate documents? Does one supersede the other?
Right. This is another good question. So typically, no, you're not putting your life insurance into your trust. There are some assets where you just are going to put a beneficiary on them. So with your life insurance, you fill out a form with your life insurance company, maybe when you got the policy, to say, I want everything to go to my spouse, or I want everything to go to my kids. And so you want to revisit those as part of your every 3 to 5 years evaluating your estate plan, because those happen hopefully not in contradiction, but in concert with your broader estate plan. You want all those to kind of not necessarily talk to one another, but work in harmony. And life insurance is a great example. A 401k or IRA through your employer, those are ones where you've got beneficiary designations too, you want to check. And most often, those are not being held in trust. You are naming the beneficiary directly.
Thank you. Go ahead, Crystal.
Stacy Robinson asks, is an annuity or life insurance policy considered an asset that can go into a trust?
Oh,
It
that
is
the same thing we just said?
Yeah, it's
Oh.
related. And I mean, it can. Whether it should is a different question, but they're assets. Anything that's an asset can be put into your trust. Whether it should is a different question.
Oh, The next question is, if you're still legally married but assign someone else, can the spouse override it?
This one's kind of a complicated question.
Okay.
So if you, there are some protections for spouses for beneficiary designations, and they kind of vary by state, and there's also some federal law at play there. I don't have a good answer for it. Usually there is some share that will go to a surviving spouse. And whether that means that your beneficiary designation, say on your 401k, can bypass them, that's a question I can't answer.
Does anyone else have another question?
And is this supposed to be an hour long? Because we're at 6:02. Just doing a time check.
Yeah, I put it for 15 minutes into 6, depending on the questions.
Okay,
sure.
any last questions? Anyone?
Can we get a copy of this whole, is it on YouTube, you said?
Yes, and I can have my team email everyone who registered the link to go on. And I know
Okay.
there's a request for the slides, so those Mitch will get those to my office, and then we'll make sure we give it to everyone who's registered.
Okay, cool.
So, oh yes, go ahead, and then we're gonna wrap up.
Yeah, good evening. Thank you for all the information. If someone were just like, well, we're all starting this out, like, would it be easier to go to a courthouse and just like take the type will there and see about getting probate? Like, I guess my question is like, what is the way of doing this, like the most cost-effective way? Like, I'm very grateful for the code, but like talking to a lawyer and stuff, if you're just trying to put something in for a family member and you want to be very, cost-effective or spend no money, what is the avenue for that?
Yeah, so the court doesn't have any role in your creating a will. The court's role is only when somebody has passed and they either died with a will or without a will. And so to my knowledge, none of them make any forms available for this. I like to think that trust and will is one of the more affordable options. Are there more affordable options out there? Yes. Are there free options out there? Also, yes. But I think it's difficult to know, especially with those free options, like, am I getting the right thing that I need? Has this been vetted? And I, like, as a lawyer, I never want anybody to have a document that's not effective, doesn't do the thing that they expect it to do. And the time-honored tradition is to go to a lawyer for that. But trust and will, we're trying to remove that barrier, at least, where sometimes you need advice and you need reassurance that what you're doing, that's what a lawyer's for. But sometimes you just need the documents. And courts are not providing will form documents, at least in my experience. So the more cost-effective way is with a platform like Trust and Will. There are also, there are different costs for different lawyers too. Not every lawyer is going to charge the same thing. Some of them will, even if you want to be savvy. So here's my advice to you. If you want to be a savvy consumer, which I encourage all of you to do, I encouraged you earlier to take advantage of the code, check us out. I said we're not for everyone. We try to be a lot of things. We are not for everyone, but compare us against other options available to you. Maybe call around, or and I say call around because most lawyers are still pretty old school, especially in the area of estates and wills. Call around and ask them, what would they charge to draft a will? Because they might not have a website, or they might not list prices on their website, but compare them, and be a savvy consumer and make sure you know what documents you're getting in advance. Make sure what information you need in advance. Another thing I'll share too, along with the slide deck, is an information sheet about the information you need to get started, because that's a common question that we have that actually was not asked today, but I'm sure some of you probably had it. But I just encourage you to look around, but I don't think the courthouse is going to be one of those options.
Does anyone else have any other questions? Last minute questions?
Oh, I wanted to make a quick comment for everybody.
You could go ahead, Ms.
I
Robinson.
I hope that with your financial assets that you have right now, that you make sure that if it's possible to set up a beneficiary for it right now, because I think people forget that for your bank account, excuse me, you can set up a beneficiary for your checking accounts and little things like that. So don't forget that stuff.
Yep, great information. Definitely something you want to look at, and you can do it right now. I mean, if you have a login to your bank account or app, that's something generally you can. If you can't change it online, oftentimes you can see it online. But definitely check it.
I just want to say something, a thought and some information. When my mom died, my brother stole a check, so they put me in probate because she had no will. So you have to be real careful because when you go to the bank, they just, I mean, I was basically administrator, right, of her will, and she worked for the city. So you have to be careful because the bank wants to see something that you are supposed to be here to, because they freeze your account. Not all the time, but they basically, because it was something, a fraud was committed, they froze the account. So I had to go through probate. You're right, to release that. I had to go to my mother's different agencies. So it's a process. I was forced into probate. So
Yeah, I hear that. And I'm sorry you had to go through that. That
but
is a
it taught
very
me something.
yeah.
It taught me a lot about probate. If you don't have a will, and then you got to go to. My mother worked for the city, so I had to go to 1199. I had to go to whatever agency to get that, that court document to provide to them. And then you got to also, if you're the administrator, because I was the oldest, so I got a fee, and then I got a lawyer because I didn't know she was a friend, a friend of a friend. So she went to my church, so that helped me. Because when you go there to probate downtown, the lady was very nice and very helpful, but you can't make no mistakes. Your thing has to be on point. Yeah. And
Yep.
because they'll just tell you, go back when you could. So it worked for me. It went through and she looked at everything. I did it correct. You just got to be careful. You can't make no mistakes because they won't stamp it. Once they stamp it, it's good. So that's it.
Thanks for
Thank you
sharing.
for that. No, for sure. I want to, of course, say thank you guys again. Thank you, Mitch, for the information. Is there any last things that you want to leave everybody with, Mitch? I'm taking away from me, making sure that I have my trust in place. I've created the will, but I didn't realize that my will will still go through probate. So thank you for that. Is there anything else you want to leave us with?
No, this has been super great. I've loved the engaged questions. Thank you, Assemblymember Jackson, for hosting. Really appreciate it. I love talking about this. So I'll be sure to share the slides with your office, share that information sheet I talked about earlier too.
Absolutely. Thank you, Team Jackson, for putting this together. Everyone else, please tune into our newsletters because this is where we give information on what's coming up next. We plan on talking about financial literacy and real estate and everything else that will be helpful for our community. So stay in tune with us. Thank you, everyone.
Thank you, everyone. And I hope everyone has a great evening. Thank you again, Mitch.
Thank you.
Yeah.